Good afternoon. On behalf of the San Diego Union-Tribune Festival of Books, I welcome you to this wonderful theater on the campus of USD. Our presentation is Law, Diversity, and the Environment with Roy Brooks, Margaret McKeown, and moderated by Robert Schapiro. I will ask that when we come to the question and answer period, that you walk up to the microphones because we are streaming, and if you're not on the microphone, the people watching remotely won't be able to hear you. So with that, enjoy.
Well, good afternoon. I'm Robert Schapiro, the Dean of the University of San Diego School of Law, and I'm delighted to be here to discuss recent works of two of our faculty members at USD School of Law, Professor Roy Brooks and Judge Margaret McKeown. Our plan's going to be to have a discussion with the authors for about 30 minutes and then open it up to your questions for the remaining 15 minutes. Now, our authors are extraordinarily distinguished scholars and jurists, but in the interest of time, I'm going to keep my introductions very brief. Roy Brooks is Warren Distinguished Professor of Law at the University of San Diego School of Law, where he teaches and writes in the areas of legal and critical theory, civil procedure, civil rights, employment discrimination, and international human rights. Professor Brooks was awarded the law school's Thorsness Prize for Outstanding Legal Scholarship 3 times, and its Thorsness Prize for Outstanding Teaching twice. He was also awarded the USD Center for Educational Excellence's Frere and Hooks Decolonial Pedagogy Award. Professor Brooks is the author of 24 books and close to 100 articles and chapters. He's received numerous book awards, including the Gustavus Myers Outstanding Book Award twice, and the Brandeis University Library Learned Research Journal Award. After graduating from Yale Law School, Professor Brooks clerked for the Honorable Clifford Scott Green of the U.S. District Court in Philadelphia. He practiced law with Cravath, Swain, and Moore in New York City before joining the USD Law faculty. His most recent book, which we'll be discussing, is Diversity Judgments, Democratizing Judicial Legitimacy. Margaret McKeown has served for 24 years as a judge on the United States Court of Appeals for the Ninth Circuit. She's a member of the American Academy of Arts and Sciences, an affiliated scholar at the Center for the American West at Stanford University, and jurist in residence at the University of San Diego School of Law. As a former White House fellow, she served as special assistant at the White House and as special assistant to the Secretary of the Interior. A Wyoming native, she serves on the board of Teton Science Schools and was a member of the first American expedition to Mount Shishpangma in Tibet, which at 26,000 plus feet is the 14th highest peak in the world. She remains an avid hiker. Judge McKeown graduated from Georgetown University Law Center and holds an honorary doctorate from Georgetown University. Before her appointment, she was the first woman partner at the law firm of Perkins Coie, and she is the author of Citizen Justice, The Environmental Legacy of William O. Douglas, Public Advocate and Conservation Champion. Well, I think, why don't we begin with you, Professor Brooks? Maybe just tell us a little bit about what motivated you to write this book. What were your goals in writing this book?
The book deals with judicial decision-making within the context of what Holmes referred to as great cases, what legal scholars today refer to as hard cases. Those are cases which raise socially significant polycentric issues like abortion, affirmative action, First Amendment, Second Amendment cases, immigration, all the way down the line. And so the book then deals with the intersection of social justice and judicial decision-making. And those themes were part of the DNA that was sort of injected into me as a student at Yale Law School. So in almost every class, especially in the first year, the discussion is about judicial process, critiquing judicial process. And I was fortunate to have this discussion with a diverse group of students. On the right was Justice Alito, and on the left, Lanu Guinier, who is a distinguished professor at Harvard who recently passed away, unfortunately. And in the middle, sort of left of center, was Willie Fletcher, or Judge Fletcher, who was senior circuit judge on Judge McKeown's court now. And so that was really heady discussion. And I also took some courses there in the graduate courses in philosophy, in which I was introduced to critical theory, which was just being introduced into the law schools and to the universities at that time. Social justice, well, I was exposed to that and dealt with that less in the classroom than in the law school cafeteria. A diverse group of students on almost every weekday night would serve up mountains of food for thought on issues of social justice. And again, we had a diverse group of students. So we had Justice Thomas on the right, which is where he is today. And we had Bill and Clinton and Hillary Rodham, who had a presence at the table. So it was really some very good discussions. But the most, I think, immediate motivation is captured in this powerful statistic. Last month, a Gallup poll reported that 75% of Americans have no confidence in the Supreme Court. That's 3 in 4 Americans have no confidence in the Supreme Court. Now, Chief Justice Roberts is sort of aware of that. He talks about that a lot, and Justice Sotomayor talks about it as well. I think she is closer to an understanding of the nature of the problem than Justice Roberts. And the problem is one of process, not politics. That's the approach taken in the book. It's not one of politics. I mean, that's the usual suspects. People talk about the politicization of the confirmation process, term limits, and that sort of thing. But I don't think that that digs deep enough. It is a problem of process and not politics. And the problem is this: the Supreme Court's deliberative process discounts or it ignores the exigencies of the diverse society that we have become. You know, major public institutions, corporations, law firms, even the ABA have all made adjustments to accommodate society's commitment to diversity and inclusion. The outlier is the Supreme Court. Supreme Court has not given any attention to diversity and inclusion in its deliberative process. Its deliberative process is committed to a concept of judicial legitimacy, what counts as judicial legitimacy, that traces back to Blackstone's commentaries, back to the Revolutionary War, and that just won't cut it today. And so that concept of judicial legitimacy is not only out of sync with today's society, but it's a drag on our democratic process. And so what I try to do in the book, and all of this really started when I was a law student at Yale a long time ago, is I try to dig deep into the problem so that we can understand it, so I can understand it, and to propose a new judicial process that is fair to both insiders and outsiders, and that comports with our growing notion of diversity and inclusion. So that's sort of it in sort of a long description of it.
Thank you. All right. Judge McKeown, but for you, what would you say motivated you in writing your book, and what were your goals?
Well, Justice Douglas, who many people are familiar with, although students today, you often say, do you know Justice Douglas? And they look at you. And then you say, oh, have you heard of Sierra Club v. Morton and Trees Have Standing? Or more recently, have you heard of Griswold v. Connecticut? Well, that's Justice Douglas. So he was a very flawed and fascinating individual. And I literally stumbled into this topic. My day job is to write opinions for the court. It's not to write books. But let me tell you why I got so fascinated by this. I was out cross-country skiing in Wyoming, where I grew up, And I came upon this homestead. It was totally covered in snow, and I wanted to have my lunch. And so I was trying to figure out how to get from this huge snowbank down onto the porch of this place when a guy comes out. And I didn't know where I was. After all these, growing up there, I said, where am I? And he says, well, you are at the Murie Ranch. And I said, oh, yeah, I know, John Muir, I get it. He goes, no. The Murie Ranch, M-U-R-I-E, Olaus and Marty. He says, they were very famous conservationists and biologists. So I said, oh. So I came down, and I got interested in them, and one thing led to another. And I found that Justice William O. Douglas had written a letter to them that said, I think you should give your entire homestead to the National Park Service so that it could be a memorial or a place, an historic place for people to come and have conversations about conservation. So I thought that was a little audacious of someone to say, I think you should give your house away, basically. And so I did a little more research, went to the Library of Congress, went to various other archives just for fun. It was really a lark, but my lark turned into this book because it turned out that Douglas, who's quite a larger-than-life figure, and these somewhat humble people from Wyoming were very good friends, and they were really movers and shakers of the conservation movement in the 40s, 50s, and 60s, and into the 70s. So as we move from conservation, preservation, and into now we use the word environment, they were there with each other step in step. And I found out there was a really interesting story to tell. And that's, of course, what we do in opinions. We take the facts, we look at the cases, we look at the law, and every case has a story. Well, Douglas had a story, and the story I discovered after quite a bit of research was that he really ran essentially a one-man lobby shop from the Supreme Court for conservation, for the environment. And at the same time, he's over here as an incredibly prodigious, very liberal Supreme Court justice. Now, Professor Brooks, of course, is talking about somewhat of a different era because he's talking about being in law school about the time that Douglas ends and steps off the court. So Douglas is the longest-serving Supreme Court justice then and now, 1939 to 1975. So it was quite a run that he had, and I'm sure we're going to get into some of the details. But to me, the story was how he basically ran this dual life as an advocate and a protester for the environment. At the same time, he was on the Supreme Court. And what were the ethical implications of that for him? And finally, what did it mean in terms of his contribution to the environment? And when I say the environment, I'm actually even talking physical environment, because there's no doubt in my mind that the environment we see today in many places across the United States was changed because of William O. Douglas.
Well, thank you very much. In some ways, obviously, both of these books are about judges and the judicial process and really present novel insights. Now, I know, Professor Brooks, in some ways, you're writing about a very traditional topic, judicial legitimacy. And you write in your book that your proposal for what you call a culturally sensitive judicial process is at once familiar and radical. Maybe you can say a little bit about how you understand it to be familiar and how you understand it to be radical.
This gets me in trouble with some of my friends, other people who write in this area, because I try to have it all both ways. So on the one hand, I do criticize the traditional process. I mean, this is what we're all familiar with. You learn this in law school. And the concept of judicial legitimacy that we all learn in law school is sort of the interplay between what Justice Holmes referred to as the logical method and the policy method. And so logical method, anything from legal formalism to textualism. Everyone's talking about textualism these days, or at least a part of it, originalism, to legal realism. And so that's what's familiar. And what is unfamiliar is the critical process. in critical process, it takes critical theory, which is a legal criticism, and transforms that into a theory of judicial decision-making, something that judges can actually use when deciding cases. Now, the critical theorists think that the traditionalists, that the problem is you got to throw them all out, okay? No more of this traditional process. That's the problem. It doesn't fit well in today's society. And the traditionalists think, well, the problem are the criticalists, these radicals, and many of them are teaching in law schools, and so we need to get rid of them. That's what the problem is. So what my argument is that, well, you know, we need both. That we have to self-consciously, when we look at a case, again, we're talking about great cases or hard cases, what we have to do is to self-consciously look at the case from the perspectives of the traditional process, and I say perspectives because they're not monolithic, and we also have to look at it from the perspectives of the critical process and resolve any differences on the basis of our commitment to diversity and inclusion. Now, that's a lot of work, intellectual work. I mean, you can sort of ask my students, I mean, you have to do all this, and I don't know how else to do it. Democracy is hard. Democracy within the context of a diverse society like ours is very difficult. You can't, if you're going to take diversity seriously, you've got to pay attention to the lived experiences of the various groups that make up our society. So, for example, if you were deciding a case involving the homeless issue, you've got to pay attention to the fact that over 90% of homeless women are sexually assaulted. That's gotta, you can't ignore it. You can't say, well, that's not a legal fact. That just doesn't cut it. I think that we're on the verge of something new, just like we were back in 1954 when the Supreme Court decided that we were going to have a new way of looking at the Equal Protection Clause. No longer will it mean separate but equal. It's going to mean equal treatment. And so that was a revolution. And when I was in law school, my professors would talk about that and what it took and what happened when everything shifted to that. I think we need the same sort of thing now because society is just so much more diverse and judges they're making decisions which have a major impact on the lives of people. And so that's what I mean. So it's familiar because it's the sort of judicial technique that we all learn and teach in law school. It is unfamiliar in the sense that we are taking critical theory and upping it. So it's no longer simply a theory of legal criticism, but now it's going to be a theory of judicial decision-making. They're going to actually say something. It's going to mean something in the context of a case. And then we're going to take these differences and we're going to reconcile them on the basis of our commitment to diversity and inclusion. That's new.
Great. Well, thank you. And when we talk about a biography of a justice, we talk about sometimes, as you said, often about reading opinions, and you say there's obviously a lot more to Justice Douglas. I think it might be interesting to give a little bit of a sense. I mean, I think this was an era in which the protest march had become popular, but it seemed that the justice really emphasized the protest hike. Maybe you could tell us a little bit more about that role and how he saw that.
Well, he kind of took it to a new height, I would say. And when people think about Justice Douglas, sometimes they think about his 4 wives. They think about the fact that he was almost impeached. He was called Mr. Justice Pangloss. He was called a communist. So, you could write a scandal book, but that's not my book. My book tries to figure out what motivated him to be this citizen justice. And the first thing was when he got on the court, very first time around in that first term, he heard a case called O'Malley v. Woodruff. And the question was this: should federal judges pay income tax? And the judge who brought the case thought, no, that judges shouldn't have to, because if we have to pay tax, you've basically diminished our salary, and that's in violation of the Constitution. Well, the court said, nuts. That can't be. Everybody is a citizen, and we all pay taxes. And so at that case, afterwards, Douglas makes this little note in his notebook that basically I've become a first-class citizen. And from that is where I get this title, Citizen Justice. But that really launched him. And so he then really felt that his church was the wilderness, basically. And he'd been through a couple of professions very quickly. He had gone to Columbia Law School, and he didn't get that brass ring. He didn't become a Supreme Court clerk, but he went on the Supreme Court 14 years after he graduated. He was basically nominated and confirmed in 2 days. So this is nothing, like contemporary times. He went to be a law professor, and with all respect to our law professors, he was at Columbia and Yale, and he hated it. And he said, the problem with law professors is they raise a lot of questions, but they don't answer anything. And so then he went on to be SEC chairman at a really young age, and he became good friends with the Kennedys, and before he knows it, Roosevelt appoints him basically to the court. And in his second decade on the court, he'd had a big horse accident, and in recovering, he wrote a book that many of you may have read, Go East, Young Man. Mm-hmm. And following that, he saw in the Washington Post that the editor said, yes, the Park Service should build a highway down to the C&O Canal and pave over part of that. Has anybody here been to the C&O Canal in Washington, D.C.? Well, Douglas reads this, and he says, that's not right. So here he is, sitting justice. He writes an editorial in the Washington Post and says, come hike with me. And if you come, then you'll understand why there should not be a highway along the C&O Canal. So he goes on a 189-mile hike. One of the people he went with was Olaus Murie, who I mentioned before from Wyoming. He was the head of the Wilderness Society. And they get done, and so here's what he did. He used what I think became a formula. He finds a threat in place. He has a big public protest. Then he forms a committee. He's the chair, of course, of the committee. And then he lobbies hard to Congress, to the president, National Park Service, Forest Service, or whomever. And then he has success. And he actually saves a piece of America from the bulldozer. And so he did that time and again. And here's a guy who, when he was a kid, he had polio. So he was bullied. He was made fun of. His mother wanted him to be president of the United States. And while he was on the court, actually, he was mentioned to be president, or more importantly, a likely vice president to President Roosevelt. That didn't happen. We all know Truman was the vice president. Roosevelt dies. So Truman says to Douglas, well, why don't you be my vice president? And he said, not directly to Truman, why be number two to a number two? And so he stayed on the court and then began this kind of bifurcated life of, protest, committees. He had protests everywhere from Washington State to Washington, D.C., Maine, Texas, you name it. He was all over the country. And that signature way of which he did it really became his view as an environmental or a citizen justice. And of course, we know that some people would raise their eyebrows and say, I thought he was a Supreme Court justice, not an environmental advocate. He reconciled that in his mind. I think there's some ethical issues there in terms of what he did, even under the, the ethics of the day. But as far as he was concerned, he could play a role, and he did. So you can imagine if you have a problem out in Kentucky and you want to save the Red River Gorge, it's like that movie, Just Call Saul, just call William O. Douglas. And he comes down and he marches with you, and you get amazing publicity.
I remember that when I was in law school, just going to law school, that Justice Douglas wrote a book called Points of Rebellion.
Right.
And that was the Bible of the student protest movement. At that time, we said, see, we got someone, an establishment figure who's who has given us his imprimatur to what we're doing.
But he also wrote, apropos of your work, he wrote a wilderness Bill of Rights. So he took the Bill of Rights to the Constitution and he played off of that, and he wrote a wilderness. He wrote 50 books.
Yeah, and he was a traditionalist, at least at the very beginning, because he worked at Cravath, Swain and Moore. I worked at Cravath, Swain and Moore,
Right.
and I looked at some of his old papers there.
Right.
And he is really considered to be the father of corporate finance law.
Right.
Yeah, and which is what I practiced when I was there. I mean, he was very talented, very controversial.
They never knew he would turn out to be so liberal. In fact, he thought he didn't like Cravath, so he thought, well, go
Yep.
back to Washington State where he grew up. And my former law firm, Perkins Coie, offered him a job for $600 a month. Cravath offered him a job for $5,000 a month. So he hustled himself back to Washington, D.C., and then he said, I hate this. And that's when he went to the SEC. So.
Yeah. And I think it was Gerald Ford who sought to impeach him.
Correct. He did. He did.
Who then ended up, he retired under Gerald Ford, and
Yeah.
Gerald Ford then had to say some nice things about him.
Yeah, exactly.
But it is fascinating. I mean, grew up in the West, we think of him as being this rugged figure,
Yeah.
and then also chairman of the Securities and Exchange Commission. So,
Right. Well, he went, after he was a law professor, he went down to Washington because they were doing a whole study of a lot of the corporate shenanigans. And so he was an expert at all of this. And no one would have imagined that he was going to turn into probably the most liberal justice of those decades. But, he had a lot in common with Roosevelt, and he played poker with Roosevelt, and he hobnobbed with ambassadors. So it turned out he was really kind of part of the fabric of Washington, D.C.
I mean, it's a little bit, I think, of a different model of a Supreme Court justice. It just, may surprise you that, as we've said, he was not a judge. And in fact, when he joined the Supreme Court, none of the justices who were there had prior judicial experience, except for Justice Black had been at a police court judge for a couple of years. But it just wasn't the path. These were public figures who then joined the court. Of course, now it's a very different court. So maybe we just end, Professor Brooks, you present this idea of putting diversity and inclusion at the center of judicial legitimacy, of judicial process. Are you at all optimistic that the Supreme Court or perhaps other courts, or what's the path forward with actually implementing your plan?
Yeah, and some of my students always ask me, who's standing in the path of this? This seems to be so obvious to us. That's Generation Z, okay? I don't know. I mean, I think that the basic recognition has to be is that you cannot have a society that's moving in this direction and judicial decision-making and law moving in that direction. That, by definition, is judicial illegitimacy. And if that is recognized, I mean, if Douglas were around today, he probably, maybe I could persuade him. But I think that what has to happen is that it has to start in the law schools, because the judges are doing only what they were taught in law school. And so it has to start in law school. I think it is starting. Boy, I've just gotten 2 new books sent to me that will apply critical theory to civil procedure in some systemic fashion. And so I think that it has to happen at the law school level. It's going to take time. And I know the criticalists say, no, it can't take time. We don't have time. But I don't see any path forward other than this slow process that all sorts of reforms take shape in a democratic society.
Yeah. And he's perhaps getting more justices on the Supreme Court who have somewhat of a different perspective, different life experience might be helpful, and maybe we're seeing a bit of that.
Yeah, and we are. And also justices who are not afraid of critical theory. Like Justice Kagan is, and she was at Harvard when she was the dean there. That was a hotbed of critical theory. She understands it. So does Justice Sotomayor. And to understand that, who's afraid of critical theory? you know? So I think that that's part of the process of change, that critical theory. It's really a major part of law school education today, but it has to be, individuals have to feel that they can be appointed to the court and still be a critical theorist.
Well, with that, I think it's time to turn to you, our audience, and we'd really enjoy hearing questions that you might have. Again, please do come to the microphone since we are also online.
I have two very quick questions if there's time for it. One for Professor Brooks about the legitimacy. I think it mystifies a lot of people how in the Dobbs decision, Alito can talk about, basing this notion on tradition and legitimacy, that there's no tradition of abortion in America when that's just demonstrably false. And for Judge McKeown, I was curious if you might be able to talk about whether you think there's any relationship with Supreme Court Judges Douglas's notion of environmentalism and his role in, for example, overturning the vagrancy law in terms of void for vagueness and his concepts of American freedom. Thank you.
Yeah, well, that is supposed, Justice Alito is committed to textualism, not just textualism, but to originalism, which is Justice Scalia's brand of textualism. And so, for example, he dissented in the case in which the Supreme Court said that under Title VII, the LGBTQ community has rights. And he dissented on grounds of textualism, even though Justice Gorsuch, who wrote it, said that he was applying textualism. So the problem, you're talking about the Dobbs case, I understand that. And the problem with that, of course, is that there are lots of unenumerated rights. The right to travel, for example, one person, one vote. I mean, you can go down, there's a whole list of that. But if you take a originalist position, then minorities, people of color, women, the LGBTQ community, you're going to lose. You're absolutely going to lose. As a matter of fact, I don't know how any self-respecting, maybe I shouldn't say this, but originalism is a little nutty and a whole lot slutty. It's about commitment not to law but to history. But every single major historian says that it makes no historical sense. Absolutely makes no historical sense. So it's more of a political statement, I suppose, than legal analysis. If you are committed to originalism, then there's no way in the world that you can support Brown versus Board of Education. Because the original public meaning of equal protection under the laws in 1868, at the time that the 14th Amendment was ratified, was separate but equal. The schools in Washington, D.C., and in every state in the country were segregated before and after the ratification of the 14th Amendment. Equality meant separate but equal. So there's no way that you can get to Brown through originalism. That's why I say it's a little nutty and what else. As an African American, I could not support it.
So to the second part of your question, ruling as void for vagrancy law, this really hits at the heart of who Douglas was. He had two abiding themes. So as you go through his cases, you can see these. First theme was the importance of wilderness as a spiritual refuge, and once you lose it, it's gone. And the second was that he believed the Constitution was meant to get the government off the backs of the little people. And that fits right in to his view that, upholding this kind of vagrancy law was just wrong, and that, in fact, the Constitution should be invoked to get the government off the backs of the little people, the vagrants.
President Dom.
Hello, thank you. My question is for Professor Brooks. I would first like everyone in the audience to know that it's an honor to be able to take Professor Brooks's class, and I, really am grateful for that opportunity. And as you've encouraged me to do before, I'm I'm going to bogart you
Okay.
and say that after having read and considered diversity judgments, I no longer believe that there is judicial legitimacy in traditional theories, positivism, pragmatism, and traditionalism, because they were made for and by the straight cis white man. If I understood your comment correctly about integrating both traditional and critical process in judicial decision-making, how can you justify the legitimacy of the integration of the two processes?
For democratic reasons. Because in a democracy, you're not going to have everybody who agrees on everything. And I made reference to my time at Yale Law School, which I cherish, because we had so many diverse people sitting around the table almost every night, and we sort of knew that some of us were going to do well. Some people who did do well, we didn't see that coming. But I cherish that because we have differences of opinion, and that's how you grow. You don't grow by talking to people who agree with you. You grow by talking with people who don't agree with you and then saying, what are your reasons? Let's lay it out, okay? With people of probity and intelligence. I think that as a matter of democratic process, and that's what this book is really about, okay, democratic process, I think that you have to take into account, you have to respect traditional process, positivism, pragmatism, and even nominalism, and you also have to respect critical process in all of its variations, symmetrical, asymmetrical, and hybrid, and engage them in a very respectful and genuine way, and then figure out what promotes diversity in this case. It's easy if everybody comes out the same way, and you do have some cases where that happens. But where that doesn't happen, I think that it is very useful and even necessary to think about how can we resolve this case in a way that is going to promote diversity and inclusion. And I know that there's a problem of precedent. Well, what do you do with precedent? Well, that's what we need to ask Alito. What do you do with precedent? So that doesn't bother me at all, the fact that we may be moving, the judge may be moving away from established law. Yeah, I think so. I understand what you're saying. Yeah, and again, a lot of criticalists say the traditionalists, they're just about maintaining the hegemony of straight white men. And so they are illegitimate. Let's not talk about it. I might be foolish. I don't know. We'll see. I want to give it a try. And 5 years from now, I might say, I was wrong. Throw the book out. I was wrong. But for now, this is where I am.
Well, I just want to mention, there's some of the theoretical concepts in critical theory that Professor Brooks has been discussing. They're, of course, laid out very elegantly at the beginning of the book. But I know sometimes people think these can be very abstract, and just hope that people know that what Professor Brooks then does is to actually apply them to a series of specific cases to actually illustrate what these would mean in practice, which is really fascinating and really, of course, worth following up. Please.
Hi. Sorry. I have a question, but first I want to give a very quick shout out to thank Judge McKeown for, she's going to be on a panel next Thursday, sponsored by the County Bar Association, Superior Court, and Society of Professional Journalists on the toll of declining trust. Can America's faith in the courts be restored? It's going to be a great program. It's free, and although it's sold out in person, you can watch it on Zoom. But my question is, along those lines, because of recent declining trust in the courts, there's been some renewed talk about possibly expanding the number of justices on the Supreme Court. And of course, the last time this happened was more than 100 years ago. But the expansion then was to match the number of judicial circuits, U.S. Court of Appeals circuits, and which we only had 9 at the time. Today we have 13. Is there any momentum toward any serious discussion of possibly moving toward an expansion of the Supreme Court to match the number of judicial circuits today?
I'm going to leave that for Professor Brooks.
Well, I don't see it happening. I really don't. And I think I think these political solutions are short-sighted. So what are you going to do? Every time there's a new administration, you're going to rebalance the court? That really politicizes the court. And the problem is really not who's on the court, but rather what they're thinking with their... I'll give you an example. So we have a case, okay? So we have a mother with 2 kids living in California, and she's suing her ex, who lives in New York, for child custody and support. And the question is whether or not the court in California has personal jurisdiction, can exercise power or control over the non-resident defendant. And so the court has this doctrine that it uses to decide these cases called minimum contacts, which says that, you know, in order for a court to exercise jurisdiction over the non-resident has to have some ties, relationships to the state, okay? And so the Supreme Court has decided this and said, well, no, there's no jurisdiction here. You're going to have to go to New York to sue for child custody and support. There's no jurisdiction because there's no minimum contacts, because minimum contacts only applies to commercial ties and relationships to the state, of which the defendant, non-resident defendant, has none. So the critical feminists will come along and say, hey, wait a minute. He's got 2 kids in California. Isn't the child at least a minimum contact? You see, that's the sort of thing that we have to look at. You know, justice is a process that necessarily involves many voices. And that case that I cited to you was written by a liberal justice, Justice Marshall. So again, it's not who, it's the thinking, and we got to go back to law school, got to change things up. This is back in 1954. This is where it's got to start, in law school.
I'll just mention again, in terms of perspectives, I believe that was a case where one of the things the justices said was, well, if we hold the father liable in a court in California, that'll be a disincentive for a father to have his children go to California. The idea about, well, what about the mother in California?
Yes.
The assumption being, well, of course, a mother would want her children to be there. So it was really quite
absolutely,
you could say throughout. Please.
I just have a question about nominating people to the Supreme Court. So Justice Douglas has reminded me he did not come from the appellate court, and it seems like every justice now is from the appellate court. Or
Yale or Harvard.
And that too. Would we be better served by having people with different life experiences and from different law schools on the Supreme Court?
Well, I mean, I think Justice Douglas would probably agree with that. And we've had varying people over time. You know, we don't really have anyone from the political world right now. Justice O'Connor came from the political world. She had been in the legislature in Arizona. Others have come from the political world. So there was some thought at one point, not within the last decade or so, that we should look out and find someone from the political world. But when we talk about diversity, I think we mean everything. We mean law school diversity, we mean background, we mean type of practice, where did they come from. But increasingly, as you point out, everyone, other than Justice Kagan, who came from Harvard, and then the solicitor's office, has come from an appellate court. And I suppose if you're a nominating party, you might say, well, one thing about coming from the appellate court is I have a record that I can see that you established. Now, that can be good or bad, but someone who comes from an appellate court has a lot of opinions behind them before they get there. So that's been a lot of the conversation. But of course, you have to go back in time and see what's been the evolution. Where did people come from? They came from politics. They came directly from law. They came ambassadors. All kinds of people, went on to the Supreme Court. But now we have a fairly narrow cross-section at this point. Come back in 20 years, and we may give you a different answer.
It'll be interesting to see if, I mean, Elena Kagan, hardly an outsider in this perspective. I don't know. Professor Brooks, do you have any perspective on whether we should get justices with different life experiences?
I think we should get justices. I think we should get justices who are educated properly, educated in a way that is going to be consistent and useful in today's society. That's what I think. I think because again, if you focus on particular individuals, especially diversity, I mean, I would prefer to have like a Justice Brennan on the court than a Justice Thomas. Okay, that's just my own preference there, but I would want all of them on the court. Okay, so that's just a way of saying that we can't look at like skin color or even gender for that matter. I know that that's what we do, but the first George Bush, he says, okay, you want color? Here you go. Here, I'll give you Thomas. He's going to take Thurgood Marshall's place on the court.
How about somebody from the University of San Diego Law School?
Oh, that would be great. I think the dean ought to be on the court.
I mean, thank you. Thank you. Yeah, I don't know how much diversity bring there, but it's interesting to think about different, perspectives of thought. I'd certainly say at the University of San Diego School of Law, we talk a lot about diversity, equity, and inclusion. We certainly mean diversity broadly, including different ways of looking at issues, and that's certainly what that brings. Well, unfortunately, I think our time together has come to a close, and I just will say that I believe our authors will be signing books afterwards. I will also say that these are wonderful books and wonderful people, and I remember Professor Brooks was saying they were sitting around in his small group, I think, at Yale, saying who was going to do well. Well, I would say that there are different ways of defining what it means to do well, but these are certainly two people who have done good in the world. So please join me in thanking our authors.
Thank you. Thank you. Thank you. Thank you.